Well, thank you all for joining us. My name is Melissa Fetterhoff. I am the president of the Nashoba Valley Chamber. So without further ado, I am going to turn it over to you, Glenn. The floor is yours.
Okay, thank you, Melissa, and thank the Chamber. Small businesses are obviously critical to the economy. There are a lot of statistics here, but I think we've all come to really appreciate our small businesses during this shutdown, and we hope that as many of them as possible can emerge from this, not just for those owners and not just for us as customers, but also just for the economy. We need our small businesses to survive this. So the program today, it has two components. One is bankruptcy avoidance or bankruptcy alternatives. So again, ways to avoid bankruptcy. And the other is a discussion of bankruptcy, and particularly the new subchapter 5 small business reorganizations provision of chapter 11. So this is a new opportunity, a new option for small businesses who find themselves needing to resort to bankruptcy. And for some of you, this might be the first look at that. So the focus of the presentation is going to be on leases and loans, other commercial debts, not going to go over any of the relief or financing programs, PPP or any of that, and also not walkaways. And what I mean by a walkaway is someone who's looking at their business, thinking about maybe not reopening it and just walking away from it. That is a possibility, but that's not something that we're going to cover here, and it's not a possibility that one can exercise without consequences. But for some people, that is what they will wind up doing. So the relationships that we're going to be talking about today are going to be those between tenant and landlord, borrower and lender, customer and supplier, all of which are some form of debtor-creditor relationship. In terms of bankruptcy avoidance, the first part of the program, these are also known as bankruptcy alternatives, non-bankruptcy resolution, out-of-court resolution, which is a very lawyer-centric way of looking at it, renegotiation, restructuring, or workouts. It's what we're talking about here is when a business finds itself unable to make payments or in some sort of default on a lease or a loan. What are the alternatives? So in terms of renegotiation and restructuring, what is being renegotiated or restructured? Again, leases, commercial loans, and possibly other business debts. Leases are fairly straightforward. I mean, a lease is a contract. You as the tenant, pay your rent, abide by the terms of the lease, and you get to occupy the space. A default on a lease is a basic breach of contract. The landlord's remedies in a default on a lease normally include late fees, penalties, termination, and eviction. But as in any breach situation, the parties can also reach an agreement to work around the breach, and we'll talk about that a little bit. The reason that I say that the landlord's remedies are normally include late fees, penalties, termination, and eviction is the reason I say that that's normally the case is that right now that's not entirely the case. But I hope those pictures weren't blocking your view. There's a moratorium in Massachusetts on evictions. It's Chapter 65 of the Acts of 2020, or House Bill 4647. It became effective on April 20th, and it covers residential and small business tenants. lost my ability to forward. There we go. So small business premises, as I said, small business tenants are included here. So a small business premise is a space that's used for commercial purpose, for profit or nonprofit. The company has fewer than 150 employees. It's not a multi-state company, and it's not a publicly traded company. So for most small businesses in the area, they will qualify as small business tenants for the purposes of the moratorium. What it does, the moratorium prohibits non-essential evictions, and non-payment of rent is included as a non-essential eviction. So you cannot be evicted simply for non-payment of rent. It does not include evictions for leases that expire during the moratorium. So if your lease expires during the moratorium, you can still be, the landlord can still commence eviction action against you. But otherwise, they cannot. Things that the landlord cannot do: they can't serve eviction notices for non-payment of rent. They can't file new eviction cases in court. They can't charge late fees or other penalties for non-payment. And they can't report the balance to a credit reporting agency if the tenant provides a notice to the landlord. The notice has to be made within 30 days of the missed payment, and it has to state that the non-payment was due to financial impact of COVID-19. There's a form that the state provides. This is just the top of the form, but this is the name of the form: Notice and Certification from Small Business Tenant, Financial Hardship Related to COVID-19. It's just a 2-page document with not a whole lot to fill in, but you do need to provide that to your landlord, and it is accompanied by a financial hardship spreadsheet that you have to work through. What the landlord can still do during the moratorium is they can terminate the tenancy. So if you don't pay your rent, they can terminate your tenancy. They just can't evict you until the moratorium is lifted. They can send a notice to vacate the premises, so an eviction notice, but again, they can't pursue that eviction in court. And they can use prepaid rent, such as if you paid your last month's rent at the beginning of the lease for their own expenses, for expenses related to the property, but they cannot use the security deposit for this purpose. They have to keep the security deposit separate. The moratorium is scheduled to expire the earlier of 45 days from the lifting of the state of emergency, whenever that happens, or on August 18th, but the governor can extend this to no later than 45 days after the state of emergency is lifted. So if the state of emergency was lifted on August 17th, the governor could extend the moratorium for another 45 days after August 17th. And it remains to be seen whether this will be extended. But right now, this is when the moratorium is due to expire. Keep in mind that it's only a moratorium on landlord actions. All unpaid rent is still due. It's not wiping out your rent. It's up to the landlord and tenant to reach an agreement on unpaid rent and on the lease going forward. The opportunity to negotiate will vary lease by lease, property by property, tenant by tenant, landlord by landlord. It's just a negotiation. One would hope, and I've heard that landlords have been good about working with tenants through this. One hopes that continues. For a lot of spaces, one would imagine that there are not going to be a lot of people lining up to rent the space if the current occupant is evicted. But it's just a negotiation that would take place between landlord and tenant. Important to make sure that any restructured lease is realistic. So whatever arrangements you make about the unpaid rent, whether you amortize it over the remainder of the lease, you add it to the first few payments once you can resume paying, you tack it on to the end of the lease, whatever it is. It's important to make sure that the restructuring is realistic, just so that you don't have to go back and do it again. Switching over to loans, from leases to loans. So with loans, we're talking about lines of credit, we're talking about term loans, secured and unsecured loans, so bank loans, other financing loans. And with loans, we have two kinds of defaults, and people always think of the second one, but not always the first one. So you have technical defaults and you have payment defaults. A technical default occurs when you haven't had a payment default yet necessarily, but you're in breach of some provision of the loan. It could be a covenant in the loan agreement, could have to do with financial ratios or other benchmarks. It could have to do with a duty to provide financial statements. It could have to do with a duty to notify the lender of a likely or impending breach. It may have, a particular breach may have a grace period associated with it, or a cure period. So while you're technically in default, if you cure the default within a certain period of time, you provide the financial statements or you bring your ratios back into line, it's treated essentially as a non-default. But otherwise, you can be in default of a loan agreement and not necessarily know it if you're not familiar with the terms of your loan agreements. So it's very important to look at those agreements and look for all of your obligations as the borrower. Payment defaults are obviously payment defaults, failure to make a payment on a loan. The lender remedies in the event of a loan default are numerous. The lender can decline to provide any further funding, including on a line of credit. So if you're not all the way drawn on your line of credit and you're in default, they don't have to let you exercise the remainder of the line. They can accelerate paydown requirements, can increase the interest rate to some higher default rate. They can exercise their security interests, so foreclose or take possession on a lien. And these remedies can be automatic or they can be at the option of the lender. So again, important to read your loan agreement to know what happens in the event of a default. One would hope that borrowers and lenders, especially now, would be able to negotiate some alternative around shutting down a line, around calling a loan, around exercising a security interest. And the negotiated alternatives come in really three forms. So there's a waiver, there's forbearance, and then there's a loan modification, and we'll go over all three of those. A waiver is simply an agreement by the lender not to recognize the default. So essentially they waive the default. They waive their right under that particular default. It essentially returns the party to their pre-default state, almost as if the default hadn't happened. But it does not waive future defaults. It's very important to know that. If you get a waiver on a particular default, it doesn't mean that the lender is waiving its rights under all future defaults. And the waiver needs to be memorialized in a waiver agreement. A forbearance, which is also known as a standstill, leaves the default intact, but the lender agrees to refrain from pursuing remedies for a period of time. So they forbear from pursuing remedies. It's almost like a self-imposed moratorium. During that period of time, they may defer payments. You may work under a different repayment schedule. The lender will often ask for a waiver or release of claims from the borrower. So sometimes when a loan goes into default, that's when a lender discovers that, oh my gosh, we didn't perfect our security interest in a certain piece of collateral or a certain class of collateral. And lenders will take this opportunity, if they grant a forbearance, to want to clean that up. But that is something for borrowers to be aware of when you get the forbearance agreement from the lender. It's probably going to include waivers and releases of claims against the lender. Waivers and forbearance agreements are intended to provide breathing space. It's to give the borrower a chance to catch up. Obviously, to do this, the lender has to believe that the borrower is capable of catching up. And I just have a couple of bullets here to talk about how that might play out over the next few months in this crisis. People have talked about a possible soft reset over the next couple of months. So as the crisis was bearing down on us and as the shutdown was being imposed, a lot of lenders let their customers, their borrowers, go ahead and max out their credit lines. They weren't doing any additional due diligence or credit analysis at the time, and therefore a lot of companies are maxed out on their credit lines. Over the next couple of months, there might be a soft reset where they'll go ahead and continue lines, extend lines for most of their customers, only for companies businesses that can't reopen or really don't. It's obvious that they're not going to make it. They won't. But then in the fall, they're going to then sift through and decide, okay, who's going to make it, who's not going to make it, and then they're going to exercise their remedies under defaulted loans. Anyways, that's one school of thought on how this might play out. Loan modifications are different. This is not just breathing space. This is a longer term solution. It's a restructuring, a rewriting of the loan itself. And it's a negotiation. And so the borrower will bring certain goals, wants, needs to the table in terms of the restructured loan. They'll want a reduced interest rate if they can get it. They'll want to extend the maturity date, maybe have deferred payments, amend covenants that they know are they're going to have difficulty abiding by, and maybe have additional flexibility to bring on subordinated debt or alternative funding. The lender's wants and needs are, as you would imagine, the opposite in terms of what, or at least their wish list, what they might bring to the table. They might want a higher interest rate. They may want quicker paydowns on revolvers, possibly shorter maturity date on term loans, additional collateral, additional personal guarantees, additional or revised covenants. They may want to have a lockbox or other control over cash flows. They may want increased reporting or oversight, and similar to the waivers and forbearance agreements, they'll want waivers and releases from the borrower against any claims that they might have against the lender. So what does a loan modification ultimately look like? Well, it depends. It's a negotiation. So hopefully the two sides will work together but understand that lenders are going to go with whatever approach will maximize their chance of being repaid. As the borrower, you want to convince them that their best chance of being repaid is to work with you, not to shut you off, not to foreclose, not to repossess, but to work with you. And the lenders will have some motivation to do this. They'll want to maintain good relationships that they have. They won't want to weaken the borrower if there's a chance that the borrower would be able to perform in the future. If shutting them off right now means that they won't have a chance to survive, that may not be in the lender's interest. As unsecured lenders may get less in bankruptcy, and especially they'll be cognizant of that if of pushing companies into bankruptcy. Termination and foreclosure are expensive, and the lender may not want the collateral. If you think about the collateralized assets in your business, equipment loans, used equipment, things like that, they may not even want the real estate if you own your business real estate. So lenders will have some motivation to negotiate, but as with the leases, this is going to vary loan by loan, borrower by borrower, lender by lender. But we hope that lenders will work with borrowers. The key here is communication. So for any of these bankruptcy avoidance strategies, the key is to communicate and to get out in front of this as much as possible. You communicate with your landlord, communicate with your bank, communicate with your suppliers, state the situation, state your intention and your ability to survive. They need to hear that from you. Explain to them why it's in their interest to work with you. And the goal here should be minimal or no surprises. But the key here is communication. If you're going to wind up with some sort of a negotiated settlement, negotiated arrangement that will keep the relationship, the lease intact, keep the loan intact, keep the business going, communication is just critical. Now, if a company's in distress and they're not able to negotiate their way around it, their way out of it, bankruptcy is an option. For small businesses, traditional bankruptcy options have been Chapter 7 liquidations and Chapter 11 reorganizations. Those are really the only two on the table. Chapter 13 is for individuals with a regular income, but basically liquidation or reorganization. And those are still your two options. It's just that up until now, Chapter 11 has generally been out of reach for small businesses. Chapter 11 reorgs they're incredibly expensive, they're incredibly complicated, and just not an option for most small businesses. That changed, or may have changed, this February. There's a new subchapter 5 of Chapter 11. It's called the Small Business Reorganization Act. It became effective February 19th. It was passed last November, I believe, and it became effective February 19th, just in time. It was amended in part by the CARES Act, and I'll mention that. It is a greatly streamlined and much more affordable option compared to a traditional Chapter 11, a full-blown Chapter 11. Your Neiman Marcus, your Sears, all the big retailers, the airlines, when the big companies go through, they're going through a traditional Chapter 11. That's overkill and out of reach for most small businesses, but now with subchapter 5 as an option, it might be possible for a small business to reorganize itself, restructure its debt, and survive without having to liquidate. So who qualifies for subchapter 5? a person, including small proprietors and business entities, engaged in commercial or business activities. At least 50% of the debt of the business must have arisen from the business. It has to be business debt. So for business entities, that's it's pretty much all business debt. For sole proprietors, to take advantage of this, at least 50% of the debt that they're trying to get out from underneath has to have arisen from the business. It excludes single asset real estate businesses. So if the business is to own just one piece of real estate, not eligible. The act as passed allowed for only up to 2.7, I think it's 2.76 million in secured and unsecured debt. So for a business with payables and equipment loans and the like, it's not hard to get up to that level. But the CARES Act increased this limit to 7.5 million for 1 year. That extends through March of 2021. So if you're a small business and you have less than $7.5 million in secured and unsecured debt, you can take advantage of subchapter 5. Big qualification here. I put this as a qualification because there has to be a viable plan. There has to be it has to be realistic that the business can survive this, can emerge from this if they reorganize their debt. If there's no way to do that, then you're not going to get the plan approved. So subchapter 5 won't help you at that point. But if you can put together a plan, if you can reorganize your debt and pay it off over 3 to 5 years, then you can come out of this intact and in much better shape. So how do these small business reorganizations work? Well, the goal is a consensual plan of reorganization. We want the debtors and creditors to agree, and there's a lot of incentive for both to do that. But the plan can be forced on creditors. So you might ask, well, if the goal is a consensual plan, why did you wind up in bankruptcy if you could have gotten there? Why not have just gotten there out of bankruptcy? Well, sometimes you can't get there. You can't get there without the bankruptcy court being involved, or you can't get there because some creditors just won't go along with it. The business gets to keep its assets in exchange for paying off as much of its debts as it can over a 3 to 5 year period. So you're going to submit a plan 3 to 5 years and pay off as much of the debt as you can, and we'll talk about how you do that. The debtor remains in control of the business. So while a trustee is appointed, the trustee does not take over your business. You continue to run your business unless you misbehave, at which point the trustee can step in. But the way this would work in hopefully all cases is that the debtor remains in control of the business. As in all bankruptcies, an automatic stay is issued upon the bankruptcy filing. That means that there can be no foreclosure, no repossession, and no further collection efforts on any debt as of the date of the filing. The debtor comes up with a 3 to 5 year plan to pay creditors, so a plan of reorganization. Upon either approval or completion of the plan, unpaid debts are discharged, they're eliminated. And conceptually, if you're familiar with Chapter 13 personal bankruptcies, where you get to keep your assets and you pay off, you come up with a plan and you pay out of your income going forward. There's a conceptual similarity here. So there are two ways that this can go. Under a consensual plan, the debtor proposes and the creditors accept a plan under which the debts will be paid in whole or in part. Probably not in whole, otherwise you wouldn't be in bankruptcy if you could just pay them off. But if you can pay them off in whole over 3 to 5 years, then that's fine. Unimpaired creditors are those whose claims will be paid in full. Impaired creditors are those whose claims will only be partially paid. Those will generally be the unsecured creditors. And all classes of creditors agree to the plan. So if this is the case, if this is the circumstance, then it gets approved as a consensual plan. If this is not the case, then we go to what's called a cramdown plan, and it is what it sounds like. If the court approves the plan, it is crammed down the throat of the creditors who would not go along. So the plan can still be approved and forced on the impaired creditors. So the people who are not going to get 100 cents on the dollar, creditors who are not going to get 100 cents on the dollar, if the secured creditors receive the value of their secured claims. So pretty much whatever the liquidation value of the collateral is, as long as the secured creditors will receive that through the plan, then the plan can be approved. And as for unsecured creditors, creditors who don't have collateral interests, it has to be fair and equitable. As long as it's fair and equitable, the court will approve the plan. So you need to meet these two requirements. Secured creditors get pretty much their liquidation value, and the plan is fair and equitable towards unsecured creditors. What is fair and equitable? It comes down to disposable income. It's called the disposable income requirement. All of the projected disposable income of the business during the 3 to 5 year term of the plan must be used to pay unsecured creditors. So again, conceptually like a Chapter 13 personal bankruptcy, where pretty much all of your non-essential income, anything that you don't need to pay your expenses, gets used to pay creditors. Similar in a business context. So all the disposable income of the business during the 3 to 5 year plan has to go toward paying unsecured creditors. So what is the disposable income? It's all of the income of the business less payments of expenditures necessary for the continuation, preservation, or operation of the business. So what you're going to do here is you're going to do a pro forma 3 to 5 year income statement, cash flow statement, and anything that any income that is not necessary for the continuation, preservation, and operation of the business is going to go toward paying your creditors. But you do get to it's net of all necessary expenses of the business. Well, what are the necessary expenses of the business? Well, it's not just keeping the lights on. It's the idea here is to help the business to get back on its feet, to be able to survive, not just for 3 to 5 years, but to be able to survive long term. So it can include reinvestment in the business, such as upgrades or expansions, if necessary during the 5-year plan, or it can even include reserves. If you need to maintain reserves for ups and downs in revenue, you can do that if they're necessary during the 3 to 5 year plan period, and that's what you would be arguing in the plan that you submit to the bankruptcy court. The bottom line here is that the plan must be viable. It has to be achievable. And the definition of that is that the debtor is at least reasonably likely to be able to make all the payments under the plan. So it has to pass the sniff test, and it has to provide some appropriate remedy, which may include the liquidation of assets to protect the holders of claims or interests in the event that payments are not made. So it has to have a fallback. There has to be sort of a plan B. So here's my plan. Here's all my disposable income over the term of the plan, 3 to 5 years. This is how much of my debt, my unsecured debt, I can pay off as a result of that. And here's what I would do if I'm not able to make those planned payments. The goal here is discharge. So at the end of the plan, or we'll see upon confirmation of the plan, the portion of your debt, usually your unsecured debt that you can't repay, goes away. It's discharged. It's eliminated. That's why you go through bankruptcy. You're not able to meet all of your obligations. So it's a fresh start. It's a reset. So somebody did not get paid 100 cents on the dollar in terms of what you owed them when you filed for bankruptcy. In a consensual plan, remember, there are two ways that this can go. In a consensual plan, the discharge happens when the plan is approved by the court. So up front, at the outset. In a cramdown plan, this is where some creditors wouldn't go along and the court had to force the plan on them. It's when the plan has been completed. So at the end of the 3 to 5 years, when you've made the payments that you indicated that you would, you get a discharge of those of the unpaid debts. Owner equity. In traditional Chapter 11 cases, there can't be any shareholder equity. There can't be any owner equity left at the end. Creditors have absolute priority, including unsecured creditors, have absolute priority over equity owners. So if any unsecured creditors don't get paid 100%, your equity will be wiped out. In a subchapter 5, it's possible for owners to retain equity in the business, again, as long as their plan meets the fair and equitable test. So it's not so much about what you have for equity or even assets as of the day you file. It's what you can afford to pay out of your income, your disposable income, over the 3 to 5 year term of the plan. But this can be important, I think, for small businesses. It doesn't mean that your equity in the business is necessarily going to be wiped out completely. Switching to a darker background here, because we don't want to. I don't want to dwell on this too much. I did want to include this at the end. But if a subchapter 5 bankruptcy is not an option, because the business just can't turn itself around, or if there is a subchapter 5 filing but the plan fails, the business would then liquidate or partially liquidate. That might be converting to a Chapter 7 bankruptcy. And I note here that for most small businesses, if the business is going to be filing for bankruptcy, or if the business is going to be liquidating, there may be a personal bankruptcy here as well, or there may just be a personal bankruptcy, because most small business debts, loans, are secured by personal guarantees. So if the business defaults, the creditor, the lender, is going to be looking to you individually to make good on the loan, even if the business can. I'm getting a message that my internet connection is unstable, so hopefully it's not disrupting the audio. But in a lot of these cases, what will wind up happening is that there will either be a Chapter 7 business bankruptcy and a Chapter 7 personal bankruptcy, or you may just bypass the business bankruptcy altogether and it becomes a Chapter 7 personal bankruptcy. There are other non-bankruptcy options, not as frequently used maybe, but there is a UCC Article 9 sale. So if there's a lien on an asset, on a piece of collateral, that asset, that collateral can be sold under an Article 9 sale, and the proceeds of that sale will satisfy that lien, even if it didn't fully pay off the debt. There's also receivership or assignment for the benefit of creditors, both of which are a little bit outside the scope of this presentation. So really wanted to focus here on alternatives to bankruptcy if a business is in distress, particularly under these circumstances, and then just to introduce you to the new subchapter 5 of Chapter 11, which again could be an option for small businesses where traditional Chapter 11 might not have been.